I'll start it then. So welcome everybody to the Oakland County Bar's ADR meeting for November. We are very honored to have Lee Hornberger today as our speaker. Anyone that keeps their ears open in the ADR world in Michigan should have come across Lee before. Lee is a frequent guest speaker at the ADR conference for the state bar. He's a past chair of the ADR section and editor emeritus of the Michigan Dispute Resolution Journal. He regularly gives updates on case law development in the ADR world in Michigan. He's former president of the Grand Traverse Leelanau Antrim Bar Association and a former chair of the Traverse City Human Rights Commission. So today Lee is going to help us break down a recent case from the Court of Appeals on an arbitration decision. So we appreciate Lee being here. Lee, I will turn it over to you to give us your presentation this morning.
Thank you, Tom. What we're going to be doing for roughly the next 23 minutes is discussing the Court of Appeals unpublished split decision, April 21st, in Michigan AFSCME versus Wayne County. Hopefully, everyone has received a copy of the one-page citation list, so I won't be overly repeating case citations. Hopefully, they're in the list that you have. I would suggest if this case interests you, you have the link in the citation list that you go listen to the oral argument. It's a vigorous oral argument in front of the Court of Appeals, and it's worth listening to. The basic question before us is not whether or not the award is right or wrong. I'm not saying I would have gone the same way. The issue is whether or not the award drew its essence from the collective bargaining agreement. Michigan AFSCME was a split decision. The Court of Appeals affirmed the Circuit Court vacatur of a labor arbitration award. The majority judges were Reardon and Sawyer. The dissent judge was Judge Jansen. This case involved a situation where on the verge of discharge, the employee potential grievant took retirement. The employee applied for retirement while awaiting the outcome of a disciplinary action initiated by the employer. The retirement application required the employee to agree to a, quote, separation waiver, end quote. The waiver stated the employee was terminating his employment and not seeking re-employment. The employer discharged the employee the following day. The employee allowed his retirement application to proceed. The employee then also filed a grievance pursuant to the collective bargaining agreement, CBA, seeking reinstatement. In the meantime, the county retirement system approved the employee's retirement. The employee then transferred his defined contribution retirement account money to a private IRA. The grievance proceeded to arbitration. The arbitrator in a 40-page award found that there was no just cause for discharge and reinstated the employee with suspension in spite of background alleged IRS issues and the waiver language issue. The Circuit Court vacated the award. The Court of Appeals majority decision affirmed the Circuit Court, applying the arbitration review standard stated in Detroit Auto Insurance Exchange versus Gavin. The significance of the Gavin decision, which is in your citation list, is a big part of what we're discussing. The Jansen dissent in the Wayne County case stated that because the arbitrator did not exceed its authority in issuing the award, the Circuit Court should have confirmed the award. According to the dissent, the applicability of defenses to arbitration, including the waiver document, were for the arbitrator to decide. There were only two issues before the arbitrator, which were number one, whether the employee was discharged for just cause, and number two, if not, whether the remedy was limited to back pay rather than reinstatement. According to the dissent, the separation waiver was raised before the arbitrator as a defense, but not as a total bar to reinstatement. Then an application for leave to appeal was filed. The application for leave to appeal is still pending. On September 28th of this year, the Michigan Supreme Court ordered oral argument on the application. The order indicated that the oral argument would address whether the standard set forth in Gavin, that's the insurance anti-stacking case, applies in labor arbitration cases, citing the Bay City School District case and the Port Huron Area School District case. And number two, almost like a separate issue, whether the circuit court erred in vacating the arbitrator's award. Let's briefly discuss Gavin. In Michigan AFSCME, the Court of Appeals held that Gavin applies to labor arbitration awards. Gavin involved an arbitration conducted pursuant to an arbitration clause in an insurance policy. It had nothing to do with employment. It had nothing to do with labor law. The issue was whether the arbitrator erred by finding that full automobile no-fault insurance policies could be stacked to allow the insured party to receive the maximum benefit under all the policies, contrary to the anti-stacking provisions in the policies. The Michigan Supreme Court framed the issue as whether the arbitrator's plainly erroneous contractual interpretation was subject to correction by the courts. You know that when the issue is framed that way, what the result's going to be. The Supreme Court basically indicated that the anti-stacking provisions were extremely important and no one could deviate from the anti-stacking provisions, and therefore the award must be vacated. The Gavin decision says, quote, just as a judge exceeds his power when he decides a case contrary to controlling principle of law, so does an arbitrator. So Gavin is saying the review of an arbitrator for law is the same as the review of a judge. In Michigan AFSCME, the union argued that Gavin applies only to statutory arbitration and has no relevance to public sector labor arbitration. It can be argued that if Gavin had involved a collective bargaining agreement rather than a commercial insurance contract, the award would not have been vacated. Gavin, back in 1982, discusses the overriding importance of anti-stacking provisions in the insurance industries. Gavin does not discuss labor management arbitration or Supreme Court decisions that have reviewed labor management arbitration. Indeed, there's a very important footnote in Gavin. It's the first footnote. There's two footnote 11s. This is the first footnote 11, which one should read, which kind of signifies that Gavin knows it's deviating from basic normal arbitrator award law. Going back to the Supreme Court's order for oral argument in the case we're discussing, the Supreme Court cites the Bay City School District case. In Bay City, which involved labor arbitration pursuant to a CBA, the Michigan Supreme Court quoted Gavin for the principle that arbitrators can fairly be said to exceed their power when they act in contravention of controlling principles of law. Regardless of the allusion to Gavin, Bay City held that the pendency of ULP charges before Merck does not preclude the arbitration of the breach of contract claims, even where statutory claims are submitted to Merck and contract claims are submitted to arbitration out of the same controversy. Bay City is a pro-labor arbitration case. The oral argument order also cited the Port Huron School District case. In the Port Huron School District case, while reversing a decision upholding an arbitrator's award on the specific facts, restated the narrow grounds for setting an award. Port Huron said the U.S. Supreme Court has expressed the federal policy of judicial deference in the context of labor arbitration in the celebrated Steelworkers Trilogy. This court, meaning the Michigan Supreme Court, has expressed its general acceptance of such a policy, meaning the Trilogy policy. Let's briefly go to the 1960 U.S. Supreme Court Trilogy concerning labor arbitration awards. The important one being Enterprise Wheel, which tells us that the refusal of the courts to review the merits of an award is a proper approach to arbitrators under CBAs, because the federal policy of settling labor disputes by arbitration would be undermined if the courts had the final say on the merits of awards. So far as arbitrators' decisions concern the construction of the contract, the courts have no business overruling the arbitrator because their interpretation of the contract is different from the arbitrator. And this eventually, in the Sixth Circuit, brings us to the Michigan Family Resources en banc decision of 2007. Michigan Family Resources discussed the standard for reviewing labor arbitration awards in light of the Trilogy. The union in Family Resources appealed a U.S. District Court order vacating an award. The Sixth Circuit en banc reversed because the arbitrator was acting within the scope of its authority. The employer had not accused the arbitrator with fraud or dishonesty. The arbitrator was arguably construing the CBA, and the employer had shown no more than that the arbitrator had made an error in interpreting the CBA. In the Family Resources case, it's fairly clear that even though they refused to vacate it, the Sixth Circuit did not really agree with the arbitrator's decision. The Sixth Circuit indicated as long as the arbitrator does not go against some basic requirements, the request for judicial intervention should be denied, even though the arbitrator made serious, improvident, or silly errors. The Sixth Circuit indicated it was the arbitrator's construction, not 3 layers of federal judicial review, that the parties bargained for. And that delegation of decision-making authority to the arbitrator, according to the family case, must be respected, even when time and further review show that the parties in the end have bargained for nothing more than error. The Michigan Supreme Court, on several cases, has recognized that there is a different standard for reviewing labor arbitrations than for reviewing other arbitration awards. One of these is in the Beck case that's in your arbitration list. Beck did not involve labor arbitration, but Beck is an example of where the Supreme Court specifically indicated that it would treat an arbitration issue within the collective bargaining process differently than from outside the collective bargaining process. In 36 District Court, the Supreme Court basically affirmed, if you will, an arbitrator's award granting reinstatement, holding that the just cause provision of the CBA could overwhelm a Michigan Court Rule 3.106. In Kaliva versus Norman School District, the Supreme Court indicated that in construing provisions and ramifications of the Public Employment Relations Act, this court, the Supreme Court, has frequently looked to decisions of federal courts which apply the NLRA. The policy favoring the arbitration of disputes arising under CBAs, as enunciated by the Steelworkers Trilogy, is appropriate for contracts entered into under PERA, P-E-R-A. The Rembert decision, Rembert versus Ryan Family Steakhouses, indicates that there can be a different standard of review for different kinds of arbitration. Rembert is an example of where the Court of Appeals recognized that a labor arbitration award is given more deference than other arbitration awards. This is in footnote 35 of the Rembert Award. The Court of Appeals recognized the Steelworkers Trilogy standard in the Ferndale Education Association case. According to that case, in the Steelworkers Trilogy, the U.S. Supreme Court held that the merits of the award are irrelevant when a court is asked to enforce the arbitration agreement or award. Judicial review is limited to whether the award draws its essence from the contract. The fact that the arbitrator's interpretation of the contract is wrong is irrelevant, according to the Court of Appeals in the Ferndale case. In conclusion, if Gavin had been a labor arbitration award back in 1982, instead of an insurance case interpreting the highly important anti-stacking policy of the state of Michigan, the award would have been given more deference in light of the trilogy and maybe would not have been vacated. And I suggest that footnote 11 of Gavin tends to show that. Michigan courts have repeatedly indicated that labor arbitration awards are to be given more deference than employment or commercial arbitration awards. This is because labor arbitration is meant to create peace and prevent strikes, while employment and commercial arbitration is meant to simply prevent cases going to court and people not being exposed to court decisions. It can be argued that Michigan AFSCME was incorrect in applying the Gavin standard rather than the trilogy standard in reviewing the labor